All right, we're starting in just a couple minutes.
Hey, how's it going, partner?
You're doing very well, David. Welcome. Everyone, we're going to start in just a couple minutes. Hold tight, please.
Hey, Ponder, could you hear me?
Yes, David.
So, do I have them directly reach out to your firm, or how
Oh
should
no,
we?
no. This is a Zoom.
Okay,
Um,
got you.
yeah, this is
All right.
okay. Everybody, we're going to get started. Yeah, this is a specialty Zoom tonight. How to beat Midland. We're not taking any uh, credit mastery course or outside matters in this Zoom. This is specifically on how to beat Midland. And we're going to go ahead and get started in just a minute. I'm just setting something up. Okay. Okay, we're about to get started here. So this is a live presentation on how to beat Midland. This is for my How to Beat Midland group. And this is recorded for playback. And again, we're specifically discussing how to beat Midland. We also have some students in my credit mastery course here. Um, but this tonight, we're speaking just on how to beat Midland. This presentation is recorded and will be posted in the How to Beat Midland group. I'm going to share my screen. Okay, you should see my screen here. I should be out of the way, but if I get in the way, just let me know. Okay, so tonight we're going to talk about how to beat Midland. Midland, um, we're referring to, they have, Midland funding, Midland credit management, okay, all the same, all a part of the Midland group there. Now, it's important to realize that these Midland entities, they're all debt collectors. Okay, they're all debt collectors. They are not original creditors. Okay. And um, they are um, they're all debt buyers as well. Okay. And this is important to note because as a result of them being all debt collectors, they are subject to the FDCPA. Okay. The FDCPA is a consumer protection statute. And by the way, these notes will be provided to you, so you don't have to take notes. You can just you'll be able to listen. Oops. Consumer protection statute. Um, the actual statute is 15 USC section 1692. And sec means it goes on. It starts at A and it continues on. At sec means just it continues on to different sections. I will provide you with a link and it will actually pull up the FDCPA in just a moment. Let me see. I'll go ahead and give you a link to the FDCPA. Starts at 15 USC 1692. Then it goes to 1692A all the way up to P as in Paul. Yeah. That's the link to the actual statute. We're going to jump into that. Where they come from? Well, Midland obviously was started as a business, and they're in the business of buying defaulted consumer debt. Okay. And specifically, credit card debt. Now, they're not limited to just credit card debt, but this is the portfolio that we see them, and you all likely experience them on some credit card debt. I have no idea if their portfolio includes anything other than credit card debt, but we know that a majority of their portfolio, as we see it, is credit card debt. Now, last week I had some issues with my internet, so if I happen to go silent or anything like that, I'll come back. Or if something happens where you can't hear me, you can message here or on WhatsApp if you have my WhatsApp. But just keep that in mind because I did have some issues last week with my internet being shady. But where did Midland come from? Well, they started as a business And we don't know originally what they intended to do, but now they're in the business of buying defaulted consumer debt, specifically credit card debt. Okay. As you know, credit card debt is revolving, revolving credit. Likely may show up on the consumer report as a charge off. Should be a zero balance. Okay. Original creditor will be on the consumer report, and you'll likely see, like I say, charge off and a zero balance. Okay. And if Midland is collecting a debt and you see that the original creditor is ABC Credit Card Company, and it's not a charge off and it's not a zero balance, then you may have an issue that can work in your favor, because the credit card company, how do they buy the debt? The credit card company sells the debt, which they call a receivable, to Midland. Okay. And what happens is, once that debt is sold, the original creditor no longer owns it, and consumer no longer owes it to the original creditor, which we call OC, right? Okay. And so that's why that original creditor on the consumer report has a zero balance. And they may even call it a charge off, or say sold to third party. Maybe it may say or sold to third party. Okay. You never know. It could be either or. Some of you may say, well, if they charge it all, how can they sell it? Well, despite what you've heard online by internet gurus, a charge off does not mean that it's a zero balance or that the debt is forever forgiven or forever anything. It's just an accounting principle that the original creditor, for tax purposes, didn't think they're going to get paid, so they considered it a loss, and they're able to get some tax benefit. However, they can still collect it, they can still sell it. So just to dispel that. If they didn't take that tax benefit before they sold it, that they can do that too, and they can just sell it off after it defaults at any point, after it defaults. It's a debt can be sold before it defaults, but this is not typically what you're going to see happen with credit card companies. They don't really sell debt like mortgage companies. Mortgage companies are completely different. You can close on a loan, not make a first payment, and it's already sold off to a third party. This is not what happens with revolving credit. The servicing remains with the original creditor. The debt is not frequently sold before default. Okay. And again, if Midland has it, that original creditor should be reporting a zero balance. Because why? Because once the debt is sold, the original creditor no longer owns it, and the consumer no longer owes it to the original creditor. Okay. All right. So why am I telling you all this? Well, if you know how Midland got this, it's just good to know where they came from. Okay. If you got a monster, you just want to figure out where they came from. And then I'm going to show you where you can send them, how you can beat them. Okay. It's good to know a little background about your opponent and enemy, but this is how they came about. They bought old debt, whoever that original creditor is, sold it, and the consumer, maybe you no longer owns it, owes it to the original creditor, and the original creditor no longer owns it. All right. And so Midland comes along and buys it. Now, Midland may buy from another, well, it may buy from a source other than the original creditor. How does that work? The original creditor could have sold it to a intermediary investor and you know, but it can happen. So I mention this because I don't want you to think that Midland has to buy from the original creditor. However, chain of title of the debt, which is also called what, a receivable, must not have breaks in it. Okay. What does that mean? All right. Well, all right. So say you have Capital One. They sold a debt to Acme Investors. Acme Investors sold the debt to Tertiary Group. Inc. And Tertiary Group Inc. sold this debt to Midland. Let's say Midland Credit Management. Okay. Well, if you, and by the end of the night, you're going to understand what we can use to figure out if Midland really owns this debt. But if you use some of the templates I'm going to give you to scrutinize and evaluate whether Midland owns this debt, and Midland shows you paperwork that shows sale of debt from Cap One to Acme, okay? This is what you should see. You should see some paperwork to show where Capital One sold to Acme Investors. Let's do Acme, okay? And then you should see a piece of paperwork that shows a sale from Acme Inc. To the Tertiary Group Inc. And then you should see some paperwork that shows a sale from Tertiary Group Inc. to Midland. In this case, I think we said Midland Credit Management. All right. Okay. If you see that, then okay. Chain of title has no breaks in it. Okay. Now, if your paperwork, after you send a GB letter, a 1692 GB letter, which I'll discuss in a second, and they send you paperwork where Capital One sold to Acme and Tertiary Group sold to Midland. Let's do this. Let me do this. Okay. Let's see. Let's do an example of break. Chain of title. And what I mean by title is the ownership of the debt. Title means ownership. Just like if you had a car title, ownership of a car. Home title, ownership of a house, home, real estate. When we talk about chain of debt, in this case, we're talking about ownership, a type of paperwork to show ownership of a debt. All right, here's an example of a chain. You do a 1692 GB letter, and you request a chain of title, and you see a sale of debt paperwork assigning the debt from Capital One to Acme, and then you see another piece of paper assigning and selling a bill of sale of the receivable from Tertiary Group to Midland Group. Oh no. Break and chain. No good. Okay. So you can't do that. And so if you see that, then you can be very confident that Midland is not the proper owner of the debt. There's a break in the chain of title. He can't buy something that originated with Capital One and was sold at Acme, and then Tertiary Group Inc. sold to Midland. No, that's not going to work. The only way that could work if they have a lot of paperwork to show that Acme either merged with Tertiary Group Inc. or there was a name change of Acme Inc. and the Secretary of State of where Acme is formed to Tertiary Group Inc. Okay, there are exceptions. Some of you like, what? I'll just write that down. Exceptions. Sure, there could be more, but maybe name, change of corporate name, merger. But the key thing is you need proof. Okay. Okay. So if there's an exception, they're going to have to show that. But for the most part, if you see something like this where you're saying provide a chain of title, they should know there's a break like this. They're going to have to provide you proof to show that there's no break. But looking at this, you should see there's a break and that Midland does not own what originated with Capital One. Just because you see something that says Tertiary Group sold a receivable that includes by exhibit the consumer debt is defaulted that's affecting you or whoever you're working with to Midland Group, that is not proper. Tertiary Group is not a credit card company that originated that debt. So keep that in mind, okay? Very, very, very important. If there's a break in the chain, then Midland doesn't own it until they prove otherwise. You don't have to. If there's a case where they don't own the alleged debt by proof, there's no need to try to defend yourself against them with respect. If you're in a dispute process, all you have to say, you don't own, there's no evidence you own this debt. So until you provide that kind of proof, you better not try to collect. If breaking the chain of title, then Midland should not be attempted to collect the alleged debt. Now, tonight, obviously, if they are, we're going to talk about how to deal with it. But they should not be trying to collect a debt if they are not the owner. If there's a break in the chain of title, then they're not the owner. If you ask them for the chain of title and they provide you chains of sale, they provide you with a sale or a chain of sales, and you see a break, then they are not the owner. Okay, until they provide you with proof to justify the exception, which could be something, but they change corporate name or the company merge, but that has to be by proof. They can't write you back and say, oh, well, Acme Inc. changed their name to Tertiary Group. No, you need paperwork for that. Or Acme Inc. Oh, that's one of our subsidiaries. No. Okay. Now, another exception. Um, oops, can't type. Midland Funding LLC, for example, may be operating as debt collector for Midland Credit Management. Okay. So what does that mean? In the example I gave up here, that means Midland Credit Management okay, equals the debt buyer, okay, also debt collector. Okay, don't forget that. And let's just do a plus. Well, let's do it like this. Let's do it like this. And Midland Funding LLC equals the debt collector. Okay. For Midland Credit Management. Okay. Does that make sense? All right. So how does this work? Well, the reason the group is called Beat Midland Funding and Midland Credit Management, because one of them will operate as a buyer and one may operate as a debt collector for the buyer. They're all Midland. But in this example, when you have Midland Funding LLC as the debt collector for Midland Credit Management, then you may have a letter for Midland Funding LLC, and you may even have a lawsuit for Midland. You may, I'm sorry, you may have a letter, a Dunning letter for Midland Funding LLC, and you may have on your consumer report a trade line collection showing Midland Funding LLC. And when you send your 1692 GB letter to Midland Funding LLC, they may show you a chain of title that looks like this. Okay. And you may look at this and say, well, I don't see Midland Funding LLC. Well, if you look at the letter, it will say, or should say, that the current creditor is Midland Credit Management. Okay. So it's getting a little, hopefully not too tricky, but follow me. But Midland Credit Management as the debt buyer becomes what's called a current creditor. Not to be confused with what? Original creditor, okay? Original creditor versus current creditor. All right, so if you look at that letter and they say current creditor, Midland Credit Management, and you have a letter coming from Midland Funding, then it should cue you to understand that Midland Funding LLC, in this particular example, is the debt buyer. I'm sorry. See, gotta be careful. I said it wrong. Midland Funding LLC is the debt collector for Midland Credit Management, who is the debt buyer. And the debt buyer is the owner of the debt. They're going to be listed on that letter as a current creditor. Now, sometimes the letter may also show the original creditor, because someone may see a current creditor and not know who the heck. I've never dealt with Midland Credit Management as a creditor. So a lot of times it'll have current creditor, Midland Credit Management. That should trigger you in knowing that they bought the debt, allegedly. And it should have original creditor on it, may have, I should say, original creditor on there. And that should say what? Capital One. All right. And so if you reverse that, if it says original creditor, Midland Funding LLC, and you're getting a collection letter from Midland Credit Management, then you should understand that Midland Funding LLC would be the debt buyer, current creditor, and Midland Credit Management would be the debt collector for the debt buyer. Okay. So keep that in mind. You may have to listen to this twice, but understand they're both debt collectors, but one of them bought the debt, and one of them are servicing that debt for the other, for the debt buyer. Okay. You may have an instance where the debt buyer and the debt collector is only one, but with Midland Credit Management and Midland Funding, sometimes they work in tandem, where one bought the debt and one is servicing it, but it doesn't have to be that way. You just have to take a look at it. But again, you're going to employ a 1692 GB letter to get to the bottom of it, because you want to see a chain of title. Chain of title looks like this. Then either Midland Credit Management needs to be collecting it from you, or Midland Funding may be collecting it from you as a debt collector for Midland Credit Management. Okay. When we have a situation where Midland Funding LLC is collecting it for Midland Credit Management, then we may also, you have the right to ask for their authority to collect on behalf of Midland Credit Management. Okay. And that's something we'll incorporate. That will be something that will be incorporated in the 1692 GB letter, and we'll talk about that in a second. But hopefully now you understand the relationship, chain of title, very important. The reason is because the chain of title has breaks in it, then that's a big problem, and it's no good. You really can just focus on that issue and not have to get into other legal issues, depending on what stage you're in. Any questions so far? If you do, you can unmute and ask your question, because we're going to move on. But this is a little tricky part, so I want to take questions before moving on. Any questions so far? All right. Okay, good. So, but if you do have questions, you can unmute and try.
Hey, Brian, I got a question.
Mm-hmm.
Okay, I'm dealing with a situation now with Midland Credit Management, and they are claiming to be an assignee of, I forget the name of the bank, because that part doesn't really seem to matter too much to me, because they still hire what is that, like a law firm or whatever to come into court by the time they sue. So you're dealing with two debt collectors at that point. And so I thought that maybe I could get ahead of it and contact Aldrich, Pite and Hahn, and that's the attorneys that's on this particular case. And they decided well, when you call in to speak to them, they'll tell you, you know, that some of the agents like to be real nasty with you. Well, no, you can't speak to the attorneys. You got to hire an attorney and all that. That's, you know, the only way. But after we got done speaking to Aldridge, Midland decided to send this person another letter. Now, we had, when they first emailed back in 2023, they we put in a GB letter with that CFPB complaint, which they received and all of that, and they agreed to mark it cease and desist. So what I wanted to know is, with us contacting Aldridge, Pite, and Hahn, and Midland sending this person another letter, even though they agreed to cease and desist or whatnot, because it did say on there this is an attempt to collect the debt and all that other kind of stuff. Is that would that count as a violation?
Okay, well, let's repeat what you're saying. You sent a cease and desist to who?
No, we sent a GB letter to Midland through a CFPB complaint in 2023 after they sent an email attempting to collect the debt. At the time, they claimed that they were not, you know, reporting or doing anything like that, and they marked it
Okay.
cease and desist.
Oh, okay.
And this year
They sued.
in 2024, they decided to sue on it. But
Oh,
like I explained to the guy with Aldridge, Pite,
I
and
got you.
Hine for the last case, you know what I'm saying, that it's,
Hold
even
tight.
though it's Midland that owns it, y'all are the ones who's suing on it
I
as a
got you.
debt collector.
I got you. So my clarification question is answered. Okay. So a GB had been previously done. Now, obviously, to answer the question properly, the question becomes, was that GB letter sent during the 30-day GA period? Was it?
Yes.
Okay. And we'll talk about what that means in a second. But yeah, if a GB letter was sent during the GA 30-day notice period, meaning, and we'll go over that in just one moment. That means that the GB letter triggers the debt collector to cease and desist collection until they provide proper verification. So if they end up suing on that debt, that's a method of collection, and that would be a GB violation. Yes, that's just so yes.
Okay, well, they marked it cease and desist or whatnot. So what I'm saying is, we contacted Aldridge, Pite, and Hahn because that's, you know, they're the ones that's representing them. After we got off the phone with Aldridge, Pite, and Hahn, about 3 days later, we received a letter from Midland Credit. You know, they were saying a couple of things on there or whatnot. I have to pull the letter up, but they basically were saying that, you know, this is an attempt to collect the debt and all that other stuff. That was in the big bold letters on there. So they, and after that CFPB complaint, they had said that they were, you know, they marked it all cease and desist, but probably about a few months after that, they began reporting it on the credit reports.
Well, I answered the question, and what you're
Yeah,
saying
I got
now,
you.
yeah, what you're saying now doesn't change the fact that it's a violation. But yeah, good question. In the beginning, you talked about Midland saying they were a signee, and I wanted to highlight that because that's language to indicate that they're a debt buyer. Okay, they're signee. And the example Brian gave was that there was a GB letter sent in the past, and then lo and behold, without verification being mailed to the consumer, they start suing. And that's a collection activity, and that's a violation of GB. They should have never initiated that lawsuit. And what Brian was also saying, it was marked as a cease collection because the GB requires that unless they provide the verification request in the GB letter. So thank you, Brian, for bringing that scenario up. But yeah, that's a GB violation, and we're going to talk about GB because we're going to go over the statutes in just 1 second. Okay.
Okay,
But,
so yeah, they actually violated, I guess, a few different ways here then. So that's what I'm getting out of what you're saying.
Yeah.
Okay, thank
you. Yep. You're welcome. Yeah. So yeah, when they call themselves an assignee or buyer, current creditor, then that should trigger you to understand that they're a debt buyer. But anytime you're getting collected on by Midland, you should understand that one of the Midland entities definitely bought are likely to have allegedly bought the debt, and that makes them a debt collector. And if there's another Midland entity trying to collect on it that's not the current creditor or buyer, then of course that makes them a debt collector. The example Brand just gave said, Brandon Mann was saying, if there's a lawsuit filed, which many of you may experience, now you have more debt collectors who've entered the scene. One is the law firm itself, and then the attorneys working it. Okay, so keep that in mind. Once a lawsuit is filed, or attorney demand, okay, you have more debt collectors involved, the law firm itself and attorneys working it. So attorney demand, that's a letter, okay, LTR, that's a letter. It's not the long-term relationship. That's what I abbreviate letter. Okay. Now, 7 pages of background. So now let's get down to, if anybody else has a question, you can unmute. But now let's get to how to attack. How to fight back. Okay. Well, how you fight back, I want to say sort of depends on what stage you're in, but it really doesn't. But really doesn't. In the fact that for the most part, you're going to always find yourself deploying a 1692 GB letter, no matter what stage you're in. So that's the really doesn't part. You're going to always start off with a GB letter, preferably. Now, we have other letters, CC and things like that, but as a basic foundation, you're going to be starting with a GB letter. Okay. I've later developed a GB letter 1, which is the same thing as a GB letter. Only reason we call it 1 because we also have what's called 1692 GB letter 2, which is a follow-up to letter 1. And you only use 2 if you didn't get the result you want from 1. So 1, what we want cease collection and a deletion. Okay, if applicable. When would be applicable? If it's reporting, or no CRA reporting if it's not reporting. Right? Okay. That's what we want. Okay, and if you get that, great, done. Okay, great. Why are we done? Because this debt If they decide not to continue to collect on it and delete and not report it, then you're done. It doesn't. There's no original creditor. Could they sell this debt to another party? Yeah, but they have to disclose all this stuff. No one wants to buy a debt that's been cease of collection for whatever reason. So it's rare, but yes, they could, in fact, resell the debt, but I can't say I've seen that happen. I cannot say. Just because I haven't seen it, and I haven't seen a great white shark either, but in person, but I know they're out there. So don't be limited by what we see. But I'm saying it's unlikely that someone wants to buy a debt that's been challenged, even for pennies on the dollar. But they bought it for pennies on the dollar, so they would sell it for, pennies on pennies. So, yeah, not too likely if they cease collection. And great, if it's done, usually you will get a letter back saying that they're going to do that. And when I say that, meaning they're going to cease collection and delete if it's being reported or not report if they haven't reported it yet. Okay, that will be confirmed in a letter back. If it's not confirmed in the letter back, that's a possibility too, because they could just freeze and not do anything. They don't have to tell you. But if it never pops up on their credit, you never hear back from them, that's the same thing. Okay, so if you don't hear back and you don't see anything pop up on the credit, that's the same thing. You're done. So don't jump the gun and go to letter 2 or start spinning the block on them. I wrote you a letter. I ain't heard back from you. Blah, blah, blah. That's fine. That's fine. Okay. If you're not in litigation. Let me write that down for y'all. Okay. Hold on. Okay. Okay. Silence is okay if not in litigation. Um, if you are in litigation, you do need written confirmation. Okay. Silence is not okay if you're in litigation. Okay. You understand the difference? If you're in litigation, that means a lawsuit has been filed. So if you're not in litigation and they're just on your credit and you do the GB letter, silence is okay. Obviously, it's okay they write you back saying, hey, we're going to stop collecting this debt and we're going to request that the consumer reporting agencies delete this trade line. Or we're going to stop collecting on this debt. We have not reported to the consumer reporting agencies and we will never do so. That's fine too, obviously. But if you have silence and no activity, it's all okay. All good. All right. But if you're in litigation, you need some written confirmation that this is that you've stopped that. Specifically a notice of dismissal. Preferably. With prejudice. Okay. Okay. Meaning they can't sue you again. That's what with prejudice means. But no.
Hey, Brian,
Mhm.
the attorney on the last case, which is the same people, when I did say that to him about hey man, this should be dismissed with prejudice. Oh well, no, I can't do that, but I can do it without prejudice. I'm like, well, but I mean, I don't see how you can't do it that way when all you got to do is take the word out off of it. He said, yeah, I ain't gonna do that, but I'm gonna give you the without prejudice.
Mhm. Yep. So thank you, Brandon, man. So that what I was about to say is it's fine either way. If you can get it with prejudice, push for it like Brandon Man just said he did, because that means they can't never ever see you again. They're not gonna they it's very unlikely they're gonna see you again. However, without prejudice does allow them, if they want to grow some confidence, to try again later, hoping you all asleep and forgot all the things I taught you, or they give it to you kid at the door and the kid forgets to tell you about it. But if they won't do it with prejudice and say, like Brandon Man just said, I can't do it like that, we'll do it without prejudice. By the way, if it says notice of dismissal and it doesn't indicate whether it's with or without prejudice, by default is without prejudice. Without prejudice means they could file it again the next day if they wanted to. Push for with prejudice, but if you can't get it with prejudice, yeah, that's fine. It's notice of dismissal without prejudices will do. Don't make it a breaking point because you just want it dismissed. They're likely not going to waste their time trying to come back and sue. And if they did, they're just hoping, like I said, they will catch you slipping. Y'all probably remember that song, Don't Get Caught Slipping. I think that was in the 80s or 90s. But that's what they're hoping for. But don't make it a breaking point. My point is, if they don't want to do with prejudice, do like Brandon Man did, just take that dismissal. That's perfectly fine. I put the word or there because either one is fine. All right, but you want it with prejudice, you can. All right, so now you sent the GB letter 1. And you get what you don't want. Okay. What you don't want. You get insufficient verification, docs. What do I mean by that? I'm going to go over GB statute, but GB is called a validation verification. The GB statute allows you to seek verification of a alleged debt, and then the debt collector has to send you that verification if they want to continue collecting, or they don't. They don't have to send it to you. But if they don't send it to you, they have to cease collection. The first thing is they have to cease collection until they send you the verification. Now, until you met me or until you log on to this Zoom tonight, a lot of you may have seen some guru letters, saying verify the debt without specificity. And that's like asking Santa Claus for a gift for Christmas. You can't cry if you get what you don't want. You didn't say what you want. Okay. So same thing goes with GB. If you ask for verification without specificity and they send you some statements, you can't say a doggone thing. Because you didn't say what would be sufficient for verification. So insufficient verification docs assume that you have a sufficient GB letter, which you all will have the opportunity to access that kind of letter through me. But if you use a GB letter that I've drafted asking for ABC, and they turn around and send you E documents, E as in Edward, You ask for apple, banana, celery, you got a problem. That's insufficient. You asked for ABC. Really, you asked for AB. Yeah, you asked for ABC. They sent you E, or they sent you F. That's insufficient. Okay. They like Brandon Mann just indicated earlier, they sue, turn around and sue. They report to CRAs or continue to report to CRAs. The first one means it wasn't reported before, and now it just pops up. You send a letter, a few weeks later, it's pop up on credit. The second one, continue to report to CRAs. You sent the letter, and it was already on the credit, and it continues to be on the credit before they send verification, because the consumer reporting is a form of collection. So if they're continuing to refresh and send this, update this on the credit consumer reports, then that's continuing to report. That's a problem. What else we don't want? Insufficient docs. They sue, they report, the CRAs continues reports. Silence with the above, they don't get back to you. Now, obviously, if they send you back insufficient verification documents, that's not silence. Okay, that's doing something. But hopefully you get the point. Basically, they don't send you verification documents, but they sue you and report you, continue to report you. All that's unwanted. That's what you don't want. Okay. Oops. Okay, well, the stuff you don't want, remember, if you get what you want, you're done. You're not done. In this case, that's when you go to letter 2. Okay, so letter 2 is designed for when you get what you don't want. All right, so that's when you use letter 2, because the question is, I sent letter 1. Should I send letter 2? That's the question that you may have. Well, it depends. Did you get what you want? Did they stop collecting? Did they delete it? Is it not? Are they silent and nothing's being reported? Then you're done. Don't worry about it. Don't force. It's like telling someone to leave you alone and they don't respond. You ever? It's like texting someone. Don't you ever? You are bad, and I don't ever want to hear from you. Don't you ever contact me? And you don't hear from them. You don't got no business texting them back. Did you hear what I said? Nah, you don't do that. So there's no need for a letter 2. You ever heard people do that? There's no need for letter 2. If you sent that letter 1, they stop collecting, stop sending letters, stop contact, stop calling. Or they wrote you and said, hey, we're not going to collect on it anymore. Matter of fact, we sent a request to Equifax where we report to delete that trade line. When they send you that letter, scan it, save it, and don't respond. Thank you. None of that. Just, it's done. It's done. Okay. You don't need a letter 2. You're good. You're done. Congratulations. Y'all remember that song? It was Vesta. Thanks. That's her name. Y'all remember that? RTO. Warren, remember. Okay, well, if you get what you don't want, now we have a problem. Now you know, now we're talking about, hey, it's time for that letter 2. Go. All right. So if you get what you don't want, we already went over these things. Now we're talking about letter 2. Now, you know, now you can do a letter 2. Letter 2, just lets them know that they failed their obligations under GB, you know, and you tell them you got to pay me now. Okay, you failed up here, and now it's time to pay me. This is just one more chance. Okay, that's big as that's big and small. Y'all should know that. You're giving them one more chance to act right, and they're also used to their insufficient docs sliding by with uneducated consumers, but once you listen to me for a little while, an hour at least, you're no longer uneducated, so they can't slide this by you. Send you some statements. Here goes some we got your verification request, enclosure some statements. Nobody asked for just some statements. Now, I will tell you the GB letter, the way it's written, does ask for an accounting, but the statements they're sending you is not going from 0 all the way to how much you're talking about. So anyway, it's insufficient. But to uneducated, uninformed consumer, it's now 9:03. You all been here an hour. That's not gonna work. That's not gonna work for you. Not gonna work for you because you're now unfortunate to them and fortunate to you, educated, and it's not going to work. Okay, so you're going to remind them how they fail their obligations under GB. Now when you see GB, you should know I'm talking about 15 USC section 1692 GB. Okay, so anytime you see me say GB, that's what I'm talking about. Okay, and this is how you abbreviate stuff. I'm talking about 15. Oops. Oh, sorry. 15. Okay. What did I do? $15 USC 16. See, we got comments 22 GB. All right, and then do the section sign. Insert advanced symbol section. All right. Anybody here from the Beat Midland group? You can just let me know. Let me see if you are. Don't be scared. Nobody's gonna bite you. Okay. Hold on. Okay. All right. Okay. Don't be shy now. Questions. David says, would it need a CC letter? No, we're not needing a CC letter. Tyler asked, this only applies to debts with the 30 days from the Dunning letter, correct? Okay, well, thank you, Tyler, for asking that. And thank you, David, for asking that about the CC. Okay, well, so let me put these questions in here, incorporate these. David asks, no, not necessary or needed here. Yep. All right. And then we got Tyler. I'm not going to call you Tyler the Great. I'm not going to do it. I'm just going to say Tyler. Tyler asks, this only applies with debts within the 30-day from Dunning letter. For GA. Okay, I'm just going to add that language. When you're adding language to people's quotes that they didn't say, you put it in brackets like that. Okay. Okay, so first of all, great question. All right, great question. Y'all are real smart. And great question. Well, yes and no. So yes, in the sense that, remember, GB, and remember, that's when I say GB, what am I talking about? 15 USC. Okay. Section 1692 GB. Letter only triggers GB when sent during the 30-day dispute period in a GA notice. Now, GA notice, we're going to go over in just a moment, but that GA notice, I'll just say this. All right. The GA notice, and if you, for those of you, I think y'all so smart, I think y'all may have figured out that GA means 15 USC 1692 GA. Because y'all smart like that. The GA notice tells the consumer they have 30 days to dispute the debt, or it's assumed valid by the debt collector. Okay. And Tyler asked that great question because technically that GB is not triggered unless that GB letter goes out during those 30 days. Now, I will also note that GA letter must be sent within 5 days of initial communication from the debt collector. Now, DC's debt collector to the consumer. Okay. Now, initial communication can mean anything: phone call, letter. Okay. Now, nevertheless, whatever the case, that GA letter starts that 30-day window. If there's no GA letter, then never starts. Okay. So, and we're going to go over to GA, I promise. But in short, that GA notice is what informs the consumer that they have 30 days to dispute the debt, or it'll be assumed to be valid. Tyler's question is, does this only applies? Now, for this, I'm assuming all the stuff above only applies to debts within the 30-day period. correct? And this is, again, great question. Yes or no? Yes, in that the GB letter only triggers GB when sent during that 30-day period in a GA notice. So that means if you get this letter today, if you got the letter today that has a GA notice from a debt collector, then you have 30 days starting today. Tomorrow will be the first day. Okay. You have a 30-day window to send a GB letter to trigger the beautiful and strong protections under GB. And so that's the yes part of Tyler's question. All right. So yes. Now the no part is that you're going to send this, you're going to send the GB anyway. Why? Because maybe there was no GA notice. You don't, I mean, I don't know. Maybe, person didn't save it. Maybe no GA notice was sent. You don't know when to start the, maybe the GA notice was bad, insufficient. Also, the GB letter triggers a dispute under E8. And because you're also smart, y'all may understand when I say E8, I'm talking about what? 15 USC 1692 E8. And we're going to pull that up in just a moment. This is all background. So the no means you send it anyway, but guess what? If by chance the debt collector did in fact legally send a timely or sufficient GA notice, what does that mean? If a proper GA notice is sent by the debt collector to consumer and GB letter is sent after the 30-day period has passed, then GB is not legally triggered, but E8 is, okay? So that's what happens, okay? That's what happens. That's what happens there. So any questions, unmute and ask, or you can type in the comment section. But that's what happens. But you send it anyway because you're going to trigger something. What movie was that where Denzel says he's going to leave her something? All right. Y'all got to help me out with some of this. So you're going to send it anyway because even if GA was good and you're outside the window, what I mean by outside the window? The GB letter is sent after that time has passed. Let's put it in red. Okay. Let's do it. Can I put this in white? Okay. Well, I don't know if I'm going to do it in white. Maybe I'm sure. Okay. Well, all right. Well, so yeah. So great question, Tyler, because, you know, that's important to understand what that GB is really doing. Now, the GB is sent because you're still triggering E8, and let's not assume that a proper GA notice was ever sent. Because when it comes down to it, if we have to litigate, okay, so you join late GBGA. Okay, well, you just have to replay. I am going to post this. And we are about to go over what GA and GB says. And so if you just join, I'm gonna provide these notes. Okay. Just for you. Don't sell my notes now. I will come find you. I'll put my name on it. But I will provide you with a copy of these notes. I think. Yeah, I think so. Yeah, I think so. Let's see. But yeah, but the video will be posted for you to review what I'm giving you. I think, yeah, I'll provide these notes for you.
Hey, Brian,
Yep.
I'm confused on how it automatically triggers E8. I'm pretty sure we went over
Okay.
it, but it's not registering. Right?
Okay. I'm gonna pull it up. So yeah. And I'm glad you say it like that. It automatically triggers E8, a GB letter, but it doesn't automatically trigger GB. GB, you have to be within that window. And what I mean by that window, within 30 days of the GA notice. But you know, these debt collectors, they get a GB letter, and my GB letter is fashioned to assume we in the window. But just understand in the back of your mind that you're not hitting with full, you're not really legally triggering it if you're outside the window. So, but we're coming in assuming we're in the window, but we don't have to assume we're in the E8 window, because the E8 window, that window is always open. All right. Always open. GB has a 30-day window that's predicated on GA. Okay. And we're going to open up the statute. I'm not going to keep that too much longer. But good question. We're going to go over that E8, GA, and GB. And since someone mentioned CC, we'll go over that too, Bob.
That is when they report in the credit report.
Doesn't have to be on the credit report. You just
Something to do with the credit report, E8.
E8 may not involve a credit reporting, but E8 has a credit reporting component, but there's a situation where if a debt is just starting out and it's not on the credit report, and you're within the if it's not on the credit report, you're triggering E8. So if it does go on the credit report after they receive a GB, that GB letter will trigger how it's reported by E8. But E8 does talk about credit reporting, and it basically talks about false credit reporting or failure to mark disputed. So I say it like that because, again, you could have a scenario where it's not on the credit report yet, but you got an initial communication dunning letter that has a GA notice in it, and you can do your GB right then. It's not on a credit report. You send a GB letter, it may never go on a credit report, but if it does, because of your letter, that trade line better say disputed, or it's an E8 violation. Does that make sense, Jess?
Yep.
Mm-hmm.
Yep, that's
So,
correct.
So good
Thank
question.
you.
So yeah, you're welcome. So yeah, so I gotta make the note different, right? Cool. All right. Oops, I don't do that. All right. Let's do it. No. All right, no. All right. Yeah. All right. So yeah, so yes or no, Tyler. Good question. We're almost ready to go to the statute. So any other questions? Now, after letter 2. Now, at this point, I ain't put GB. So when I say after letter 2, we're talking about GB. All right. So after GB letter 2, you still have some problems. Someone mentioned you can do what's called a CC letter. where you tell them to cease communication. It's also called a refuse to pay letter, but it all equals, cease communication. Okay. All right. But you can do a CC letter. CC is another protection mechanism. You don't want to be bugged. Say if they, if they don't follow the GB letter 1, they don't comply, and then you send a letter 2 and they still defy. You say, look, you can send a CC letter. It's going to provide another protection layer to the consumer. Issue if violated by the debt collector, and violated by debt collector, they continue to write you. It's over at this point. This debt collector has blown through all kind of roadblocks put up, and they're in big trouble. Okay, but that's really all you need. Now, if you're in litigation, guess what? It's the same steps. The letters, they're going to go to the debt collector. It may be a debt buyer, law firm, lawyers. Okay, so say, because some of you are just learning this at a particular stage, you could have gotten sued yesterday. Well, Brian, I didn't know about all this last year when I first got my first GB letter. Dunning letter, GA notice or whatever, initial communication. I just got sued and I saw your group, blah, blah, blah. Well, that's fine. Luckily, the steps are the same. If you got sued yesterday, you can still deploy these letters immediately to the debt collector, the debt buyer, law firm, and the lawyers. Okay? Same steps. Okay, no matter where you start, it's like, you just jump in. Any of y'all remember Young and the Restless? They still have that? Anybody? Come on.
Yeah, the daytime TV shows.
Have you ever seen it?
Nah, I just briefly looked at it.
All right.
Never took it up.
Oh, yeah. Well, you can jump in at any time. And that's my point. Those stories, Young and Restless, they've been on since, I don't know, 70s, 80s. I don't know if it's still on, but you can just jump in. And same thing here. If you just learned about this and you got sued yesterday or sued last month, you can just jump in. You got to act fast though, but you can jump in and do these same steps. Except now these letters don't just go to Midland Credit Management and Midland Funding if they're involved, whoever's involved. It would also go to the lawyer's law firm. And they have to do the same thing. They're now becoming debt collectors for the lawyer and law firm, or debt collectors on behalf of the debt buyer and the debt collector. Usually just remember, a debt buyer can't be a debt collector, but the debt buyer will be the actual plaintiff and the consumer would be the defendant, but the law firm, which would be the entity, okay? Let me just make that clear. Law firm equals the entity, and then the lawyers equal, individuals. Individuals are human beings, okay? Individuals, all right. So just to be clear, that's who the letters will go to. You would send these letters to each of them, the GB. All right. Additional steps. If not stopped by the GB, equals, you know, you may have a motion to dismiss. Motion to stay. And compel litigation. Answer. Counterclaim. Counterclaim. Discovery. Depending on what court and your rules in your court in the state. Because a lot of these cases may be in a smaller court, small claims court, some type of small court. Smaller courts we call kangaroo courts, okay? If you don't know why, you'll learn later. But it may involve discovery, motion practice, and trial or hearing. Also, maybe, well, before that could be mediation. Okay. All right. So now, if you, like I say, if you're in litigation, all the stuff above we talked about is here. You got a whole lot more underneath there that can be employed. It's like tool belt. You only need like a hammer and screwdriver. Up here, if you're not in litigation, you can get by with a hammer, a screwdriver, a flathead screwdriver, which is GB. Well, what's the hammer? What's the hammer? Well, no, okay, with screwdriver, that'd be GB. Phillips screwdriver, Phillips head, maybe GB letter 2. And then a hammer, CC. Okay, you got 3 tools before litigation. Once you get in litigation, use those same 3 tools against those involved, the debt collector, debt buyer, the law firm, the lawyers. However, now you have some additional tools. You need a whole tool. Up here, you can just walk around with a tool belt, but down here, you're going to have a tool box. You're going to have a box of stuff because you got motion to dismiss, you got motion to stay, compel litigation, you have an answer, counterclaim, possibly discovery, other motion practice. Other motion practice may be motion for summary judgment, something like that. Motion for judgment on the pleadings, okay, stuff like that. Or motion to dismiss. But we have that up there. We have that up there, right? Okay. All right. So mediation, and they may have a trial or hearing. So you need a toolbox for that. Preferably the ones with a little handle on you can carry it around. Not the big one. You don't need the big one that goes in the garage. You can't move it around. You need one you can just carry around some of these tools. All right. But yeah. So if you're in litigation, it's the same thing, but you're going to need these additional tools. All right. Now, okay. So any questions? We're going to jump to the statute. And I'm going to let y'all go. Okay. I don't want to keep this too long. All right. Again, I will provide you with these notes. Any questions about this? I think we're done with notes. But for those of you, okay, any questions? Okay. Go ahead.
A quick one, Brian.
Go ahead.
When you're in litigation, is that to try to resolve the situation quickly?
Okay, this litigation I'm talking about, thank you. You get sued. I'm not talking about you going after them.
Okay.
That's what I'm talking about.
All
Now, I
right.
will say this. If you're pre-lit, and above didn't work, you can sue BB. Okay. So that's maybe where you're getting at. But when I say litigation here is these jokers are suing you. You get sued by Midland.
Okay.
That's what I'm talking about here, okay? Because we're not suing somebody and moving to dismiss it. But that's what I talk about. But thank you. But yeah, I mean, if you're pre-litigation and you do a GB and you don't have a cease and desist of collection and deletion, you do letter 2, they don't want to act right, you do a CC letter, they still coming at you. At any point up here after GB letter 1, you don't get what you want, you can sue. We do that in green, okay? But here, when I'm talking about litigation, I'm talking about you get sued by Midland. Same steps. Now, well, I already sent a GB to Midland, like you said above. Well, guess what? Now you just need to send it to, you don't have to resend it to who you sent it to. You got to send it to the lawyers and law firm now. If you send it to the debt collector and debt buyer already, and it was within the window, now within the window, I'm talking about what? GB. Is there a window for E8? Anybody? Somebody. You got to answer this. Is there a window for E8? No. Tyler says no.
No.
That's right. So when I say if it's within the window, I'm only talking about GB because there's no window for E8. It's an open balcony. It's open. An open porch. So imagine E8 is that open outdoor balcony, and the GB is that sliding door. You know, there's a window there. Okay. So what my point was, if you're already GB the debt collector, you don't have to redo that. Please don't ever repeat. We don't double text here. Okay. So you already did your GB and whatever to them. That's fine. What if you didn't? Then go ahead, send it to everybody. But my point is, you don't have to redo it. You can just send them to them. Now, you may already have a violation if it's within the window and they didn't comply, but you still go ahead and hit the lawyers up because you're going to put them in a pickle too. All right. So if you're in litigation here, I'm talking about Midland suing you. That's where we are. Okay. So we're going to jump out these notes. I'm going to go to the statutes and then I'll come back here and finish up on this. Won't be much longer, maybe 10 minutes. We're going to stop sharing that. I'm going to stop sharing that. I'm going to go to our statute. Okay. We're going to jump on the statute just for a second. Oh, okay. So I gave you this. No, well, it's in the notes, but I'll provide this link, you know, in the Facebook group and everything. This is the FDCPA. As you see, there are many sections all the way up to P. We only talked about G and E. So there's much more to this, okay? But I'm just giving you, and if y'all are gun owners, you don't need to shoot all your guns to protect yourself, okay? You may just have to really grab one. But I'm giving you the formula to beat them in the most efficient way with the most potent weapons. Okay. I'm gonna mute y'all if you're not talking. Okay. So let's go to GB. Let's go to G. All right. So we talked about GB being the first letter, but the window is governed by GA. So let's look at GA. Section G is about the validation of debts. GA says notice of debt within 5 days after the initial communication. Communication can be oral or written. Communication is anything, any contact between the two. It could be text message, whatever, email, Facebook message, whatever. with a consumer in connection with the collection of any debt, a debt collector shall. When you see the word shall, understand that means it's required. Unless the following information is contained in this communication, or the consumer has paid the debt, you have to call. All right, we're talking too long. All right, shall, unless the following communication is contained in this communication, or the consumer has paid the debt, send the following written notice containing 1, 2, 3, 4, 5. Now, when you're reading the statute and you see a list, it's going to be numbered or whatever. I want you to take a look at the whole list and see what's before the last thing. If it says and, that's a conjunctive list, meaning it must have everything. If this had or, that would mean it only needed one of these 5 things. So when you're reading this law, statute, and you see the word and on a list, understand that every single thing on that list must be satisfied or else it's insufficient. All right, so this GA notice must have 1, the amount of the debt, 2, the name of the creditor to whom the debt is owed. Now, I clicked on creditor because it's defined. Now, anything in blue is defined. When they say creditor, they're talking about the person who extended the credit. The term does not include a person who received assignment or transfer of the debt. So what does that mean? We're talking about our original creditor. We're not talking about Midland funding, like the example we gave earlier. The current credit, we're not talking about current creditor. When they say credit, they're talking about original creditor. So that's why I said this letter, the GA notice is going to have that original creditor. In our example earlier was Capital One. I said Cap One, that's a abbreviation for Capital One Bank, NA. All right, so 2, name of the creditor and to whom the debt is owed. 3, a statement unless the consumer within 30 days after the receipt, okay, 30 days after the receipt of the notice, disputes the validity of the debt or any portion thereof, the debt will be assumed to be valid by debt collector. That's what I told you. This is the window that we talked about earlier. That's the window, and here is GB reference. A statement that if the consumer notifies the debt collector in writing within that 30-day period. Now, you see what it said? In writing. This notification can't be done by phone. That's why you need a GB letter, not a GB call. Within the 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain. Now, it says will up here, but down below is stronger. But they have to obtain. Will obtain verification of the debt or a copy of the judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer by the debt collector. Okay, and it has a statement that upon consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor if different from the current creditor. Okay, hear me, please wake up, everybody. Do not ever request the name and address of the original creditor. Why would you do that? Why would you do that? Why would you do that? Well,
I'm sorry, I missed this. You say why we need request? I'm sorry, that's why you say, right?
5, the notice of debt must have a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor if different from the current creditor. Well, first of all, I'm saying don't ever do that. Don't do that. I'll explain to you why down here, but don't do that. What does number 2 require them to tell you? They are required to tell you who the creditor was, but I'll explain to you why I don't want to do that, because if you request the name and address of the original creditor, instead of sending you verification documents, they can just tell you the name and address of the original creditor. But you got to read GB very closely, understand that that's a trick. So never, just understand, never ask in writing in response to, excuse me, a debt collector's GA notice for the name and address of the original creditor. You'll see why, but don't ever do it. And I'm gonna tell you why. First of all, they have to give you the name of the original creditor anyway, because we just saw this number 2. They don't give you, I'm sorry, they don't give you the address. They have to give you the name of it. You can figure out the address later from the verification documents in your GB letter. All right. GB says, and we're almost done. One more section after this, and we're done. If the consumer notifies the debt collector in writing, within the 30-day period described in GA, when they say subsection A, they're talking about subsection of this right here. GA, that the debt or any portion thereof is disputed, or that the consumer requests the name and address of the original creditor. Okay, you see that or? This is, you got, everybody wake up. And we're about done. So if the consumer notifies the debt collector in writing within the 30-day period in GA that the debt or any portion thereof, look, we have a list here, is disputed, or the consumer requests the name and address of the original creditor, are we going to ask for that? No. You see, okay, we're done with the list. We can dispute it. If you stop here, understand they're saying in writing, if you notify that the debt or any portion is what? Disputed, or you request name and address of the original creditor, comma, now we got the condition. Now the solution would be, or the next trigger would be, the debt collector shall, remember up top it said will? Okay, will is like, okay, I will do when I feel like it. But no, the debt collector shall, that means it has no option. Now, read this carefully. Cease collection of the debt or any portion thereof until the debt collector obtains verification of the debt or a copy of a judgment. Okay. I'll talk about it later. Or the name and address of the original creditor. All right. And a copy of such verification or judgment, or name and address of, or see those ors? Or name and address of the original creditor is mailed to the consumer by the debt collector. Y'all gonna have to sleep on this, but what's happening here is if you're disputing a debt, first of all, if it's reduced to judgment, they can send you a copy of the judgment because no one cares about what documents you want to see. If they got a judgment on you, that's basically screw your documents. The judgment rules. That's why up here it didn't say you can ask for a copy of the judgment. If that debt's been reduced to a judgment already, screw your document requests. They can send you a copy of the judgment. That's what that means. But if you ask for ABC documents and there's no judgment, they need to give you ABC documents. That's what they mean by that. You see the word or, that gives them an option. If you ask for the name and address of the original creditor, they can give you that and be done with you. So that's why I say never ask. You have to sort of read this over and over to understand what I'm saying, but just don't ask. But understand, if you do ask, the debt collector can see your name and address of the original creditor and be done with you. So you don't want to cut yourself short by asking for that. But back up here, it says the debt collector shall cease collection of the debt. Well, this is so important because until they do any of these things below, which is obtain verification and mail it, they can't collect on the debt anymore. So no more letters, no more calls, no more consumer reporting, technically, if there is reporting, and don't put anything on a credit if there's not, until they mail the verification that's requested. Collection activities and communications that do not otherwise violate this chapter may continue during the 30-day period referred to in subsection A, unless you've done what we just said, unless you send a GB letter in writing. You understand that? It's sort of confusing when you read that because it sounds like you can do a GB letter and they can continue. No, they're just sort of repeating and clarifying, hey, if you don't do a GB letter, they can keep doing what they're doing during that 30-day period, as long as it doesn't overshadow these rights. Okay. Any collection activities and communication during the 30-day period may not overshadow or be inconsistent with the disclosure of the consumer's right to dispute or request the name of the original creditor. Okay. So you're gonna have to read that over and over, but hopefully you understand that. Now, the GB letter triggers these obligations. Obviously, legally triggers it if you're under a GA window. Any questions about a GB? Okay.
I am more
I have a
confused,
question.
but it's fine.
Okay. Well,
I have a question.
we'll go hear both of you. You want to let Miss Jessica and then Mr.
Sure.
Mark B. Jessica, what's confused?
When you say, I mean, my issue is when they send the validation, they usually send statements, contract, the bill, sale of bill, which is only one page. I understand it's not the contract, but then what you can do there if they send that information? We know it's not complete, but still.
Okay, so what's your question?
My question is what we can do next. If I have this case with Wells Fargo, they
Okay.
actually are suing my client.
Okay, well,
I already sent to the, I'm not an attorney, but I sent the answer in her behalf. But this attorney, she complained, she keeps saying, we send the validation and we keep disputing because there is a charges. But she say, she never received the dispute paper, and she said, yeah, she did it because she never received any return mail.
okay.
Yeah, that is the fighting between what she say and what she doesn't say, or what we receive it or not.
Okay, I get
What
it.
you can do there.
So, okay. Well, we just talked about that because, let me see, I'm not sure the question of what to do. Well, we just talked, and you did what you do the GB, and we gave a list. If you're in litigation, you have to utilize the other tools. You have to answer or otherwise. We're going to go back to that. So maybe I'll jump back to that and review that. But that's, if you're in litigation, first of all, the situation is different, but it's the same. The same is you always deploy the letters. The ones that are already deployed, you don't have to deploy, but you deploy the new ones to the lawyers and law firm. Now, I heard someone said he didn't get it. I'm glad you brought that up because everything has to go out certified mail, you all. Everything has to go out certified mail. We don't ever want this BS where they're saying, oh, we didn't get something. Yeah. And also, no one should be answering a lawsuit for a client unless you're a lawyer. If you're doing it, that's like smoking weed. Don't tell anybody. Don't tell the police you're doing it because that's illegal. You can be indicted.
I know that. I helped her to technically answer.
I understand, but that's the unlicensed, unless you're a lawyer, that's the unlicensed practice of law. And all I'm saying is, even in here, I'm not going to report it, but we don't want to be talking about doing anything illegal. And so if you have someone who is in litigation, they can learn and do for themselves, just like you ever have a bump, or I don't know, you ever have like a bump on your face, and you can pop it if you want to. You can get a razor blade and scrape it off. What if someone else has a bump on their face? Can you, even if they say do it, take a razor blade and scrape it off? No, you're not a dermatologist. But if you do it, don't tell anybody. When I was a kid,
Hey, Brian.
hold on for a sec.
Okay.
When I was a kid, I had a loose tooth, and I couldn't really pull it out, so I just grabbed some pliers. I hope I cleaned them off. I hope I cleaned them off, and just sort of, it helped me get a good grip and pull it out. If I had now, if someone else that I know has a loose tooth, I can't do that. If they get an infection, it's over. I saw this case in Atlanta where there's this guy doing veneers. They had under indictment five or eight count indictment for putting veneers in people. So anyway, I say that to say that it is a crime to try to practice law, and it's very tempting because you have this knowledge. This is for you. If
Yep.
they need this knowledge,
Yep.
well,
Don't clarify.
don't clarify.
No,
But-
because it's probably I don't say correctly. That is not in litigation, but who sent the letter was an attorney's office, a collection.
Mhm.
Yeah, it's not technically, she's not in any lawsuits or nothing like that.
Okay, when you say draft an answer,
Yeah.
the answer is a response to a legal complaint. But okay, well, I'm glad to hear. But anyway, I'm not saying this to ridicule anyone on here. It's just so that you understand,
Of course.
you're going to get specialized knowledge here that's very specialized, where you're going to be able to navigate. Like Brandon Mann, he has a question. He's navigated litigation and made people dismiss cases, but understand that doesn't mean you can do it for someone else. But again, it's like what you do in your private time is your private time, but we don't want to put this on display. This is going to be posted in a group. You don't ever want to implicate that you are doing anything that you're not supposed to be doing. And Jessica clarified she's not doing that. She's talking about drafting letters. You as a credit repair person, you don't even have you don't have to have a license or anything, depending on what state you're in, to do that, and that's fine. You can help people with these issues pre-litigation. But yeah, I just want to make that clear, because some people are students and have heard this before, but the knowledge you're going to get today, you're going to feel like a super man or woman, but understand it doesn't empower you to necessarily do it for others if they're in litigation. Pre-litigation, you can under the Credit Repair Organizations Act, but once it goes into litigation, they do need to get help from an attorney, and you have to be careful because you don't want to put your neck out there. And again, like I said, if I had a tooth that's loose, I was like, hey man, can you help me pull it out? Because I don't want to pull it. You should say no, because look, I can, but I'm not a dentist. You get infected, something goes wrong, I don't want to lose my house. You get a $1 million judgment against me for my mouth being infected. All right, Brandon, man, go ahead.
Yeah, I just wanted to chime in about the certified letters part to the attorney, because when we were in that case with Synchrony Bank, when he kept asking me who I was, I said, well, I'm not here, representing anybody on this case or anything. She drafted her own answer and did all of that. But, I did personally make sure that these letters got sent out. And I said, we sent them to the attorney of record, and we also sent them to the law firm. He said, well, I don't have any record of that. I said, oh, you don't? I said, well, I pulled up my USPS app. I said, well, this right here says that y'all received it. That's what he looked at. It was like, Yeah, man, I'm gonna go back in there and look at the file and see if there's anything in the file. I mean, who did I never said I wasn't gonna dismiss it. He
Oh
changed
man.
his whole tune because he knew we had proof. I wish I actually would have had the green card, but
Hmm.
that being able to show him the
Hmm.
electronic record was more than enough.
Oh, very impressive. Yeah. Brandon Mann is in my credit mastery class, and as you see, he's giving them hell. But yeah, that certified mail, because everybody, I don't know if we got it. You see that how you play that game, and as soon as he pulled up that USPS app showing that they got it, game over. You can't deny that. I mean, you can't get something and pretend you didn't when you get the certified mail. If you don't have the certified mailing, it's pretty hard to prove that it was sent. You can swear to it, but guess what? You don't have a third party that's objective certifying that it was sent and received. So very, very important. Very, very important. And y'all gonna have to read over this. I understand that you're not gonna have a full understanding. I'm glad y'all asked the questions. Thanks, Jessica, for clarification and asking your question, because this stuff is pretty dense. I'm giving you these tools that can get it done. The screwdriver, flathead, Phillips, and the hammer. The hammer is the CC. 1692C is communication in connection with debt collection. We're going to go down to C, which is CC. It says if a consumer notifies a debt collector in writing, can't call this in, that the consumer refuses to pay a debt, or, and I say or real loud because that's a list, that a consumer wishes the debt collector to cease further communication with consumer. That means stop contacting me. You don't have to say it like that. You can say stop contacting me. Do not contact me. Or you can say cease further communication with me. That's all you have to say. The debt collector shall not communicate further with the consumer with respect to such debt. Now, if there's another debt that comes about, they can. So you may write a letter and say, don't contact me about this or any other debt. Well, technically, the CC only applies to such debt they're actually collecting on. You can't really pre-CC them. There are some exceptions. They can write back or communicate again to advise the consumer that the debt collector's further efforts are being stopped. So they can write back and say, okay, we got your letter and we're not going to contact you anymore. That's okay. And remember, this is an or. They can also notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinary invoked. Okay, so they can send a letter saying we may do XYZ. We may sue you or something like that over this debt. That's fine. Or where applicable, they can notify the consumer that the debt collector intends to invoke. Remember, this is may invoke, and they can write you and say, hey, we intend to sue you over this debt. So just FYI. That's fine too. If such notice from the consumer is made by mail, notification shall be complete upon receipt. Well, how are you going to prove they got it? Brandon Mann told you. Certified mail. I told you. Certified mail. Okay. So this is your hammer. This really puts the nail in their debt collection coffin, because if they blow past refusal to pay or that you don't want to be communicated, then that's a violation of CC. I'm going to jump to E8, then we're going to wrap it up. E8, section E is false or misleading representation. E8 says the debt collector may not use false, deceptive, or misleading representation or means in connection with the collection of any debt without limiting the general application of the following. The following conduct is a violation of this section. We're going to scroll down. There's several things on this list, but E8 says communicating or threatening to communicate to any person credit information. Now, person includes Equifax. Person is not human being. It could be, but it also includes entities like Equifax, Experience, and all those, TransUnion, etc. Credit information which is known or which should be known to be false, including the failure to communicate that a debt is disputed. So when your when your GB letter is outside the window, and when I say the window, we're talking about the window created by GA, it serves as a dispute because within it, it says you're disputing a debt. So if they ever report the debt, or if they already have it reported, the next time they communicate about that debt, they're going to have to indicate, they being the debt collector has to indicate that it's disputed. If they don't, it's going to be an E8 violation with respect to failure to mark disputed. Now, if the information they've already communicated or do communicate is false, or which should be known to be false, that's an E8 violation too, even without the dispute part. So that's where the E8 comes in this. Any questions about E8? Something very important to remember about E8 is if this debt is already reported to the consumer reporting agencies and you send and then you send a GB letter, the E8 part of it doesn't kick in to the next time they communicate, the debt collector communicates with the consumer reporting agency. They don't have to run to the CRA and say, hey, it's disputed. But the next time they communicate, which can be months, if at all, they have to communicate it. So understand that. And here's how you figure it out. When you send your GB letter, when the debt collector receives it, that's through the certified tracking, you're going to know. When you look at the consumer report, the subsequent month, you're going to look at that trade line and look at where it says last updated. If that last updated date is after the time the debt collector received the GB letter, for example, then it should say this debt is disputed by the consumer. If it doesn't, it's an E8 violation. You're going to have to replay this probably a couple times to sort of hear that, but that's how that works. Any questions about E8? Let's see here. Oops. What we got? All right. Okay. Non-repudiation. Okay. All right. Well, y'all got a question? I don't see any question. Bonded license. Okay. Okay. So good. And again, I wasn't beating up on anybody. I'm just trying to make sure y'all not over here talking about you got weed at your house or something like that, because that's just not proper to. And we don't. And I don't teach. We don't condone doing anything we can't do. Your powers are limited, and even if you are an attorney, your powers are still limited. You know, you can only practice where you're licensed. But yeah, not beat up anyone. We're all here to learn. But that's that. Okay, so one more thing. We're gonna go back and review these notes here. Okay. Back to
Brian,
go ahead. Go right ahead.
I got a quick question. So does a email satisfy GA? Like,
well, you mean like a GB letter by email? Oh,
like,
you mean
like,
yeah? What do you mean?
Yeah. So the initial communication, or like, I guess the GA. So if they're sending you a GA by email, is that satisfying that?
Yes, that's in writing.
Is that basically, I guess, yeah. Is it written?
That's in writing. That's a good question. I don't know, but that is in writing.
Okay.
That is in writing. So if they send you an initial letter, it is in writing. It didn't say it had to be printed out, but it is in writing. What's not in writing is a phone call.
Right.
You know, but text, emails, things like that. If they do it on like an airplane in the sky in smoke, I don't think that'll count, because that's not that's going to fade away. But in writing, yeah, email, letter, and stuff like that should count.
Okay.
Yeah. So
all right, thank you.
Phone call, just know the phone call where they're telling you is not in writing. If they told you everything on the phone, yeah, they're gonna have to put it reduced in writing within 5 days. Otherwise, it's not really a GA notice. But it has to be in writing. But writing can take the form of non-printed mail. Just like you can dispute it by emailing them. You don't have to give them a physical letter. But I do want you to, because you need certified mail. It can claim an email never got to them or something like that. Because these types of notices have to be received, not just sent. However, there's some case law where the GA letters they don't have to prove that you received it, but so anyway. But to answer your question, yeah, email is considered in writing. And back to what Jessica was saying about litigation, what to do, same steps here, you see, same steps. But you got to act fast because everything's on a timeline. If a person is sued, if you look at the summons, it's going to say you have to answer within a certain timeline, maybe 20 days, maybe 30 days. So all this stuff has to happen very fast. If you're sued, you have to do it very fast. Obviously, you can hire a lawyer, but if you're doing it yourself, you're going to have to act very fast to get that GB out to get them to stop it. Or else you got to jump into it and implement either a motion to dismiss. Now, with it being a credit card debt, if you're in litigation, a motion to stay and compel arbitration is a great option. And the reason you figure that out is to look up the credit card agreement to see if there's an arbitration clause in it. And if it is, you can implement this, get a kick out of court, and make the debt collector have to file an arbitration case against you, which is going to cost thousands of dollars, which they're not going to want to do. Okay. So yeah, so that's it. What I'm going to offer, this is an offer. I'm not going to ask for all your money, but some of it. What I'm going to do is for this Midland group, we're going to start a test group where I'm going to provide you with the letters and litigation templates. The letters are going to be specific to Midland. It's going to have your GB and CC letters. The GB letters are going to be specifically for credit card or revolving credit. Those of you that may have already have GB letters, you understand there's GB generic, there's GB medical, GB student loan. So these GBs is going to be specific for revolving credit. You got your letter 1, you have your letter 2, and then you have your CC letter. CC can be a refusal to pay or cease communication form. Okay, we're going to provide all those forms. Litigation templates will be all these things are listed here. Okay. Litigation templates is going to include that. Obviously, the trial and hearing is going to be tips. There's no templates for your trial and hearing. But what Brandon Mann was telling you was some tips at trial. You do your breakout. You say, hey, man, you sure y'all want to do this because y'all violating if you make it there. But the litigation templates will be motion to dismiss based on various grounds. Now, understand a motion to stay and compel arbitration is superior than a motion to dismiss. And technically, I should have that under. I want to have that under because I want you to understand that a motion to dismiss to compel arbitration is your superior go-to. If you by chance have a credit card that they bought that does not have arbitration, then you're going to have to do a motion to dismiss on other grounds. We'll have an answer template on how to answer and to counterclaim. We're going to do discovery. Now, understand most courts don't allow discovery in these small courts. So you have to look at the rules or call the clerk to say, hey, is discovery allowed in this? And discovery being allowed and discovery being required to be compliant to different things. I mean, they can voluntarily agree to submit to discovery, but if discovery is not compulsory or required, you don't want to waste time doing discovery. just like they can't waste time doing it against you. Meaning, if discovery is not allowed or required in a small claims court that you're in, if you're in it, they can't ask you for anything, and neither should you ask them for anything, because that's a waste of time. But you have some motion practice templates for the opportunity to dispose of a case before trial. We're going to provide those templates. Motion to dismiss is what we had above. Remember, motion to stay, compel arbitration is one thing. Motion to dismiss, or on various grounds, will include those various grounds that may apply. Discovery is where you do interrogatories, deposition, requests for production, documents, things like that. You can even request to inspect, premises too. You can actually go to their site. That's a discovery. Okay. Request for admission. All right, request for admission. All right, that's discovery. And then motion practice can include motion for judgment on the pleadings, motion for summary judgment. Now, these motions are not only ones that can be done by you, it can be done by the other side. So the template would be how you do one and how you defend yourself against one. Motion for summary judgment, and then motion to dismiss. We talked about that above. So that's a template. The motion to dismiss will always be filed by the defendant, because the plaintiff is not going to try to dismiss this case. Mediation is another thing where you're going to have tips. There's no templates for mediation. Mediation is where the court may require you to break off and try to resolve by a mediator before trial or hearing date, or sometimes, at the trial or hearing. They may have a little mediator person, like Brandon Mann told you, somebody have a breakout. Sometimes they may have you break out and deal directly with the attorneys and parties, just to try to mediate it party on party. But sometimes you'll have courts that have mediation services that's required to try to get you to work it out. Trial or hearing will give you tips. You heard some stories about Brandon Mann, some tips. Mediation, again, some tips. Most of your tips are going to be you organize and can show that you're going to win. Counterclaim, or the counterclaim means you sue them in that same case, okay, for violating you. And that's going to offset things. That's going to help you get negotiation power against them, because you're saying they violated you. That's what that means, answering counterclaim. So I'm going to show you how to answer, how to counterclaim, things like that. This is what we call, and I have these packages that are generic, but we're going to do a special, like a Midland dispute and litigation package. Now these is regular. All my packages is regular $397. Okay, but what I'm gonna do is, for this test group, we're gonna do some reduced pricing. It's so reduced I can't even say it. It's so reduced I can't even say it. So yeah, so we're gonna do a Midland, we're gonna do a specialty package. And if you are a lifetime dispute and lit package person, it's included. So don't even message me saying, do I get this? Yes, if you're a lifetime, you get this. If you're not a lifetime person, want to become a lifetime person, you can message me and say, hey, I want to get in this test group, but I want to be a lifetime. Lifetime To be a lifetime person, you have to be a credit mastery student, and then you can get a lifetime package license. And what that means is, as long as I'm alive giving these packages, whatever I come up with and put in writing, you can have it. You can have it. That's what that means. It's real nice. We have some lifetime people in here. But anyway, this Midland dispute and litigation package, this is the first debt collector specialty package that I'm offering, because the other packages are not specialized directly to a specific. So of course, you're going to have the officers, all the templates going to have the officers' names, their emails. It's going to be real invasive. You're going to have the direct contact information to all these knuckleheads at Midland. And so it's the first specialty package like that. Now, I would say this. Let's see. I think my birthday package with the Equifax, the three major CRAs we get real direct. We have, if you have my birthday package, you have the address, officer name, emails, faxes to these CRAs. So, but this is the first debt collector specialty package. The test group's going to have to reduce pricing as I build it out. You're going to have this reduced pricing. Of course, reduced means way less than $397. We're going to build it out. And once it's built out and fine-tuned to where we have everything in there we want, then we're gonna go regular. Okay. But for those that want to be in the test group, I'm going to give you I'm talking about super reduced pricing. And we're going to build this out. The immediate things that you need will be available in this package within the next several days. But you have, you have to, email me promptly to get in the test group. But just so you know, the basics that you need will be immediately available. Some of these things in litigation are going to be fine-tuned and modified and things like that. Even after everything is complete, on a no less than a yearly basis, things are modified and edited and upgraded to match the times through litigation and things. We come across some weaknesses and we strengthen those weaknesses. So, but the test group is going to see all that build out. This whole package may be developed fully within a week. So again, the test group, this is a limited time thing, because I could be done with the finalize everything within a week or so. So we don't want, anyway, if you want to be in a test group, if you want in, you can email me. I want to be in the Midland, you can say Midland test group, whatever subject line. And I'll send you the link. To get into that test group. You can also, if you're on WhatsApp, you can WhatsApp me. 646-450. Oops, sorry. 450-9461. Give full name and email address if you WhatsApp. And I'll get you in, and I'll get you the link, so. But this is test group. So this is to, if you're on here, if you're seeing this, you have opportunity to get into the test group. Obviously, reduced prices mean way less than this as we build out this nice package. Those in the test group, it may include some further Zooms as we build out. Because if anything we need to fine tune, may want to talk about, we'll do that. So it would include some further Zooms. Once it's built out, you know, the regular price stuff will include those Zooms that we developed to sort of go over everything. Because as we build this out, I'm going to sort of go over this stuff with you. Okay. And so those in the final package, that'll be part of it. All those prior Zooms will be up and available for people to look at and learn and things like that. But anyway, if you want in, obviously email me tonight, WhatsApp me tonight. You can do a subject Midland test group in the email, and I'll get you the proper link that you need to get in. All right. Any questions? How was that?
I didn't get to hear you. The Midland group testing group, is that part of for the lifetime members too, or no? That's something completely different.
Let's see here. If you are a
I
lifetime
missed that part.
dispute and litigation package person or holder,
Okay.
it's included. You good. It's included. You will be added to the group.
Appreciate it.
Okay. They included. If you're not a lifetime member, I mean, you have to be a credit master student to do that because it's not to the general public. You can get a lifetime package license if you're a student. You gotta be both of that. But yeah, if you're a lifetime package person, this is all, you know, I'm still alive and writing stuff up. You get it if it's consumer law related. I had this book about medical stuff, but you don't want that. That's not part of it. But this is consumer law. Anything I do consumer law, you got it. You're a lifetime person. Okay. Isn't that exciting? Who's excited? I'm excited for you. What y'all think about that information? What's your best? What's the best part you learned that you liked about tonight? That's the round. That's the best question. What's your favorite part?
A lifetime Midland dispute litigation package. Excellent.
Oh yeah. If you're a lifetime person, you get it. But yeah, so this is I'm excited because this is a specialty package that's going to allow you to dig deep. And I have a whole Beat Midland group. So this is really for them. We got a lot of people that are affected by Midland, being sued by Midland, being pursued by Midland. This is how you can beat them. I want to offer this to them, and also we have credit master students that can take advantage of this too. So, okay. So again, this test group is for a limited time, maybe 1 or 2 days, 3 days, I don't know. So if you want in, you be sure to email me, subject Midland test group, or WhatsApp me, say Midland test group, and to my number, law firm number, and we'll get you in there. Okay. But again, limited time. So if you're seeing this video, or if you're here tonight, you got to do this soon, because once I close out the test group, then we're talking, it's still a good deal, but we're talking regular price. So if you want to be in the test group, you holler at me now. Otherwise, you come in and tell in, no test group numbers. Okay. Price so low I can't even say it, y'all, because I commit myself to somebody else to that low price. But obviously less than that. All right, well, that's it, y'all. Kept y'all way longer than I wanted to, but y'all had some good questions and I had to give you all the information. So yeah, so you got the email. I will post this in the group. But yeah, again, if you want to be in a test group, you have to let me know ASAP and we can get you in there. All right. Any other questions before we go? Well, listen, y'all have a good night and thanks for joining in.
All right.
Good night.